All right, welcome back. Intellectual Property Law Part 2. So we're not quite done with trademark, but we're pretty close. And so this is where we left off talking about the concept of ambush marketing. And so effectively what you've got in ambush marketing is that some company paid a lot of money, sometimes tens of millions of dollars, in order to be the official sponsor of an event. And so by being the official sponsor of the event, then they're able to have their logo all over the event, and hopefully then that advertising will drive buyers to purchase whatever their product is. So in the case of ambush marketing, though, you have a company who is not the official sponsor of the event that tries to get attention on their product instead of the official sponsor. So basically, they try to get a bunch of advertising without actually paying the fee to be the official sponsor. So, for example, and one of the most prominent examples in American sports actually comes from the 1996 Summer Olympic Games in Atlanta. And so that picture there in the lower right is from those games. That's Michael Johnson setting the world record in the 200 meters. And so one of the things that you'll notice about Michael Johnson there is you can see a pretty obvious Nike swoosh, the little check mark there on his chest. And if you look closely at his gold cleats, you can see that those are Nike as well. So that year for the 96 games, Nike wasn't the official sponsor of the event, but instead they paid a much lower fee in order to have the right to design the track team uniforms. And so the Nike swoosh was all over the place, but the actual sponsor of the event was Reebok, and Reebok had paid $20 million in order to be that official sponsor of the Summer Olympic Games. But when people were asked after the event who the official sponsor was, almost everybody, a decided majority, said that Nike was the official sponsor. So Nike was able to ambush that to get a whole lot of publicity for much less fee. And so they look like they were the official sponsor even though they weren't. So another case, more recent but international, comes from the 2010 World Cup. And so in 2010, Budweiser paid upwards of $25 million to be the official beer sponsor for the World Cup in South Africa. At a game between Denmark and Holland, a Dutch beer company, Bavaria, paid 36 models to attend in orange mini dresses and to try to generate publicity for their own beer. With such a large block of attractive and similarly dressed women, and you can see a picture of them there, they garnered significant on-camera time and coverage, and then lots of comments from the play-by-play and color guys that were doing the TV broadcast. So Bavaria had sold the dresses as part of a gift pack. So if you lived there, if you were Dutch, you were familiar with that brand of beer, and you were also familiar with what those dresses symbolized. And to drive that point home even further, prior to that stunt, Bavaria made sure that the dresses would be recognizably associated with their brand by paying famous Dutch TV personality and model Sylvie Meese to wear them on her regularly scheduled appearances on TV. So if you were Dutch, then you knew what those dresses represented. You knew that that was a Bavaria advertisement there in real life. And so effectively, since Budweiser is that title sponsor, Bavaria kind of jumped in and got a bunch of publicity for free, essentially, and so drove people to purchase their product instead. So one of the things about ambush marketing is that it's pretty tough to challenge, especially under American law. So remember that with our trademark law, one of the things that the plaintiff is going to have to prove is that there was a sense of confusion because of that trademark infringement. And so in this case, the infringing company or the ambushing company is not trying to create confusion, and instead they're actually trying to set themselves apart. So Bavaria wasn't trying to confuse people about Budweiser. They were trying to get TV time for their brand instead. Same thing with Nike in the 96 games. They weren't trying to associate themselves with Reebok in any way. They weren't trying to confuse customers. What they were trying to do was to sort of pull attention away from Reebok and drive buying force to their brand. And then the other problem from a legal standpoint is that these tend to be really short-lived campaigns. So, they're only during the 2 weeks of the Olympics or only during the approximately 2 weeks of the World Cup. And so lawsuits can drag out for years. And so usually if you're on the receiving end of ambush marketing, it it hurts your company, it costs you money, but it's going to cost a lot more than you're going to be able to win back in damages most of the time if you actually pursue it in court. So typically, for the company that's been damaged, it's not really worth their time to pursue a legal remedy. So that's one of the other challenges under U.S. law. All right. So does that mean that I can, from a trademark standpoint, does that mean that I can never use some other company's marks or the marks that somebody else controls? And the answer to that is no. There are certain circumstances under which you can use a trademark that is controlled by somebody else. And so that concept is described as fair use. So you've probably noticed that during all of my presentations, I used lots and lots of marks I don't control. And so I'm covered under fair use. Now, I'm covered under fair use in that I'm using them in an educational fashion. I'm not trying to use those marks to seek any sort of a profit. I'm using them to as examples and then to explain concepts and that kind of stuff. So I'm covered under fair use from an educational standpoint. And so that would probably be accurately described as classic fair use. So in the case of classic fair use, what you're doing is describing that company's own product. So if I were talking about the Green Bay Packers and I were using their marks, and I'm describing the players on the team or some legal action they took, or some, like if I talked about their personal seat licenses or anything else like that, I'm describing that team and describing the things that they've done. And so because of that, that would be covered under classic fair use. So if there's a lawsuit, they would become the plaintiff. So I'm describing the plaintiff's own product. I'm describing them. So in the case of things like newspaper reports where, the Journal-Sentinel in Milwaukee is using the Green Bay Packers logo, they're talking about the players and all those sort of things, those would be covered under classic fair use as well. And obviously under First Amendment rights. So there would be more than just classic fair use. There would be other components to that if the Packers sued the Journal-Sentinel. But from a trademark standpoint, that would be classic fair use. And that's as opposed to nominative fair use. So in the case of nominative fair use, what you're doing is you're comparing products. You are using the plaintiff's marks to describe your own product. So we're assuming there's a lawsuit here. So you would be the defendant, and then you'd be using the plaintiff's marks to describe your own product. So an example of nominative fair use is here. So you can see that the graphic of the ad says, "How do you like your chicken noodle? With MSG or without?" And so obviously this is an ad for Campbell's Select Harvest Soup, and they are comparing their brand and the ingredients in their brand to a competitor, to Progresso. And so what they're trying to insinuate, obviously, is that MSG, they're insinuating that MSG is unhealthful, and so wouldn't you want to buy their product because their product doesn't have that unhealthful additive? So they're using another company's marks, but they're using it to describe that company's product and to compare it to their own. So there are some limitations on that. So you can use the other company's marks to describe your own product and to do a comparison, but you have to use their marks no more than necessary in order to describe your own products or services. So that's one part. So you can't just have their marks over all of your stuff. And then the second part is that when you're talking about their product, your conduct must reflect a true and accurate relationship between the plaintiff and the defendant's products and services. So you can't use their marks and then make untrue claims about them, which, obviously. So it has to reflect, it has to be accurate about their product, can't be intentionally misleading about their product, and again, you have to use it no more than necessary. So this one came up in 2019. Yeah, because it's 2020. So in 2019, after the Super Bowl, there was a big ad campaign during the Super Bowl and after, where Budweiser had an ad campaign against the company at the time that was called Miller Coors. And so what they did is they ran a series of TV ads and then a series of billboards and print ads that talked about the fact that Miller Lite uses corn syrup. And so you can see one of those ads here. So this is from just off the highway in Milwaukee. And the billboard simply says Miller Lite uses corn syrup. And so they're using the name of a competitor brand. In the TV ads, they actually use the Miller Lite marks, and they use the Coors Light marks, which are, again, both owned by what was at the time Miller Coors. It's now Molson Coors. And so one of the things that Miller Lite said, or Miller Coors said, and I'll show you a couple other things. So that's about the lawsuit that Miller Coors initiated in response to that. And so you can see on the Bud Light packaging there, so they had 4 ingredients: hops, barley, water, and rice. And I've actually heard radio ads where they're still running this basic campaign. So Budweiser really highlights the fact that they have 4 ingredients in their beer. And so they talk about all the things that Miller Lite has, or that Coors Light has, and the fact that they use corn syrup. So an important thing to know, though, is that the fermentation process for beer requires some sort of a simple sugar. And so Miller Lite and Coors Light both use corn syrup, and Budweiser uses rice. So they all use a simple sugar to sort of foment that fermentation process to feed the yeast, basically. And so the question then is what Budweiser has done, is that intentionally misleading? Or would that be covered under nominative fair use? Is Budweiser simply comparing their own product to Miller in a way that reflects a true and accurate relationship, or are they being intentionally misleading? So it gets tough. I don't think they. I don't know. I'm torn. I don't think Miller would be successful or will be successful in their lawsuit because, for example, that billboard just says that Miller Lite uses corn syrup, which is true. They do. Now, what Budweiser is hoping is that because the public generally has negative associations with corn syrup and believes it to be unhealthful, that they'll say, oh, well, Miller Lite uses corn syrup, that's unhealthful, I'm not going to drink Miller Lite. Instead, I'm going to drink Bud Light because it doesn't have corn syrup. Now, an important thing to know is that the simple sugars that they use during the fermentation process, like the rice or the corn syrup, don't actually end up in the beer. So it may be misleading in that they're leading a consumer to believe that there's actually corn syrup in the bottle. But Budweiser was very careful in the things that they said. So I don't think that Miller would be successful in their suit. One of the things that Miller actually said in the lawsuit was that Budweiser was engaging in dilution by tarnishment, that they were trying to damage the goodwill that Miller Coors had built up with their brands. And again, in the case of tarnishment, they're associating. So the idea with tarnishment is that you're associating their product with something that is shoddy or unhealthful or unwholesome. And so, yes, but it's true. And so, at least on its face, it's true. So it'll be interesting to see how that lawsuit ends up working out. Like I said, I don't think Miller Coors will be successful, but certainly in the face of that massive ad campaign, they had to try to do something. So I understand why they would initiate a lawsuit based on misuse of their trademarks. All right, so I skipped over those couple slides. That's just an elaboration on kind of what I was talking about there. So an interesting wrinkle in the Lanham Act, which again is what outlines trademark protection, is that Section 2A, as you can see there, prohibits registering trademarks which may disparage persons living or dead, institutions, beliefs, or national symbols. So basically that is a prohibition on you trademarking things that are disparaging of people. So if you say hurtful things about people, it also extends to things like racial slurs, cuss words, those kinds of stuff, or those kinds of things have typically not been granted trademark protection because they fall under this Section 2A of the Lanham Act. So the question I have for you then is, can the name Washington Redskins be trademarked? Or would that be considered something that is disparaging to persons living or dead and thus not eligible for trademark protection? So the title of this slide, you can see there, the Washington NFL franchise. And so for a little while there in 2017-ish, ESPN, every time they talked about the Redskins or this particular NFL franchise, they referred to them as the Washington NFL franchise rather than their team name. And so it was because of some legal actions taken with respect to trademark law and the Redskins. So I'll give you a little bit of background on the team name and also on some of the background on this trademark law. So the background on the team is that in 1966, the Redskins filed for trademark protection for the Redskins, which was granted in 1967 without opposition from Native American groups. In 1992, 7 Native Americans petitioned the Trademark Trial and Appeals Board to cancel the mark pursuant to Section 2A of the Lanham Act. And so the basis for that cancellation was that Section 2A prohibits that disparagement. And so that disparagement is prohibited if, quote, a substantial composite of persons are likely to find the offensive mark, or likely to find the mark offensive, end quote, then it can be canceled. In 1999, the Trademark Trial and Appeals Board ruled in favor of the Native American petitioners and canceled the trademarks. In 2003, so obviously the Redskins appealed that decision, or that organization appealed that decision. In 2003, a district court found that the Trademark Trials and Appeals Board erred in finding that the name the Redskins was disparaging to Native Americans. Further, that franchise sought the defensive lashes, which means that the plaintiff took an unreasonable time in bringing the suit. Because remember, the trademark was granted in 1967, and the lawsuit wasn't initiated until 1992. And so the court said that the best time to resolve the suit would have been in 1967, shortly after the mark was granted protection. But since the Redskins were allowed to develop those marks in marketing for 25 years before the lawsuit was initiated, the court found that the plaintiffs failed to bring their lawsuit in a timely fashion, and so they allowed the team to continue using their marks after that 2003 decision. But wait, it keeps going. So the court also said in the 2003 ruling that the plaintiffs lacked standing because they could have filed the suit earlier. So in 2006, a new petition was filed with younger complainants who had just reached the age of majority, which is 18, and therefore could not have filed their petition any earlier. In June of 2014, the team's trademark was once again canceled for being disparaging. The cancellation would not go into effect until the club had exhausted all of their appeals. So while this is going on, there's another lawsuit filed in 2010 that's going to have a lot of bearing on whether or not the NFL franchise can control their mark. And so that other lawsuit was initiated by a Portland-based band. So in 2010, Simon Xiao Tam, who is the front man for a Portland-based band, tried to trademark his band's name. The band went by a commonly used racial slur for people of Asian descent, and the band was called the Slants. Tam claimed that he chose the moniker in order to reclaim and take ownership of a hurtful epithet. A trademark examiner refused to register the band's name on the basis of Section 2A, finding that the mark disparages Asian Americans. And so, again, under that section, you can't trademark a name that does that. So then the following year, a second examiner acknowledged Tam's attempt to reappropriate the term, but still rejected the request for the mark on the same ground. So essentially he appealed it to the Trademark Trials and Appeals Board, and a second examiner ruled the same way that the first had. So Tam appealed the decision twice more on the basis of violation of his First Amendment rights. After the second appeal, a federal circuit court ordered a rehearing of 2A's constitutionality. So then the question becomes, while 2A does say that you can't trademark these things, is that something that is actually a violation of constitutional right to freedom of speech? So upon rehearing, the court rejected Section 2A's ban as message-based in terms of, so effectively what's happening there, what the court is finding is that the government is saying you can't say a particular thing because that particular thing is offensive, whether that is a racial slur, cuss word, etc. So that is message-based denial. So remember that restrictions on freedom of speech are subject to strict scrutiny, which means that the government action must be necessary in order to achieve a compelling government interest. So, and further, remember that a compelling government interest is something that the government has to do, and necessary means it's the only way to do it. So then the question before the court is this Section 2A, this sort of, I'm going to use the term censorship, Is this, or we'll go with restriction, is this sort of restriction something that the government has to do? And is this the only way to do that? So the court said that seeking to suppress disfavored speech is not even a legitimate, let alone substantial or compelling government interest. The government, because the government in this case is actually defending Section 2A to itself, so this is, who would this be? Anyway, these are government attorneys arguing for Section 2A. So those government attorneys contended that free speech wasn't banned. The band, in this case, was still free to use the name, it just couldn't be protected by trademark. The court replied that denying protection disincentivizes selection of potentially disparaging remarks and thus has a chilling effect on free speech. In June of 2017, the U.S. Supreme Court sided with TAM, and the ruling was unanimous, with Alito, one of the justices on the Supreme Court at the time, wrote that the disparagement clause in the Lanham Act violates the First Amendment's free speech clause. Alito wrote, quote, "Contrary to the government's contention, trademarks are private and not government speech," end quote. The ACLU hailed the decision, saying that it prevented the government from playing the speech police. So what ultimately happened is, because of that ruling in the TAM case that found that this restriction was unconstitutional, that it is infringement of one's First Amendment rights to freedom of speech, that in fact the name the Redskins, while it is probably disparaging, despite I think the 2003 court ruling, that it doesn't matter from a trademark standpoint, because that prohibition on the part of the government was not something that was constitutional. So the Redskins can trademark that name, even if it is something that a substantial composite of persons are likely to find offensive, because that section is not constitutional. So, and with that, then ESPN stopped calling the team after that appeal came out in 2017. ESPN stopped referring to them as the Washington NFL franchise, and so they started using the club name again. So yeah, I was gonna say that there's a radio host on sports radio in Austin that still refers to them as the Washington racial slurs, which I always find a little bit amusing. All right, so in terms of the extent of trademark loss, I have a question for you that you can see there. So if I tell you the game will be played on blue turf, does any particular team come to mind? And the answer, if you're familiar with college football at all, is probably Boise State. So a little background on the Boise State blue turf. If you've ever watched games there, you know that their turf is blue, and when they play at home, often their entire uniforms are blue, and it makes the game somewhat difficult to watch because they're hard to see. But Boise State has had blue turf since 1986, and the reason they got blue turf was because the athletic director at the time was upset that he was going to have to pay $600,000 to replace the aging turf in the stadium, and in his words, nobody was going to notice. And so he decided that if he was going to spend that much money to replace the turf, he was going to get some turf that people would notice. And so they bought all blue turf. And so for a long time, they were the only team that had a turf color other than green. And eventually they started pointing to that and started using that as part of their recruiting pitch. So they had been a 1AA team or FCS team, and eventually they moved up into the highest division of college football. So they moved up into 1A or FBS division. And so they used, like I said, the blue turf as a way to recruit. And ultimately, by the mid-2000s, they'd put together some pretty good teams. And so in 2007, Boise State got a win that essentially catapulted them into the national consciousness when, in 2007, they beat the Oklahoma Sooners in the Fiesta Bowl. And it was a really, really close game. Really, it was a great game. They won on a Statue of Liberty trick play, and then afterwards, the running back proposed to his girlfriend, who was one of the cheerleaders, and it was a cool game. And so because of that, Boise State got lots and lots of publicity. And so shortly after that game, Boise State filed to trademark blue turf, and they argued that when consumers thought blue field, they thought Boise. And so the initial application was rejected by the Trademark Trials and Appeals Board because of lack of distinctiveness. And so they basically said, that nobody knows that that's you. That's just all you have is a blue field there. That's not something that you can trademark. So Boise State reapplied the following year in 2008, and in that reapplication, they pointed to a bunch of advertising, in fact, $2.2 million worth of advertising that singled out their blue field or incorporated their blue field. And so they were showing that they were really trying to make that a distinctive for them, that they were trying to create an association between blue field and their university in people's minds. And so in 2008, they got approved for that trademark. So there are now about 30 blue fields across all levels, but Boise's is the only one in NCAA's Division I. So Boise actually has a director of trademark and licensing whose job it is to pursue possible infringement. And so one of the things that Boise argues is that if people think of a field that's any color other than blue, they're going to think of Boise, which is an interesting and I think too far-reaching argument. But because of that, they essentially tell other schools, look, if you want to have a field that's anything other than green, you need to come through us. And so for the most part, schools have. So if schools are going to put in some kind of other colored turf, they'll go to Boise and say, look, here's what we're going to do. Can you sign off on it? Because if Boise decides that your turf, let's say you're going to do blue turf for another Division I school, if they decide that that's going to create the likelihood of confusion, then they're going to sue you for trademark infringement. And so for the most part, schools just find it easier to go to them and say, look, we're going to put in a gray field or some other color, and so can you just sign off on this and say you're not going to pursue us for trademark infringement? So, and in general, Boise says yes. So as long as it's not a field that is essentially college football, they usually say no to that. So, for example, Michigan, the University of Michigan, built a blue field hockey field after Boise secured their trademark, but Boise gave them permission because it was field hockey, not football. But there was a case in 2014, or an example in 2014, where there was a North Carolina high school that asked for permission to install a blue turf field, but they shared the facility with a local college football team, which I think was Division III. But because it would be a football field that was blue, that was used by a college, Boise State said no in that case. And so it's a really interesting argument, like I said, that Boise claims that the fame, quote, transcends the hue, end quote, is the words of one of their assistant athletic directors. So typically trademark attorneys argue that that's a stretch, but all of these other fields, so you can see here, so this is Eastern Washington, this gray field, and you can see, that one's Eastern Michigan. This one's Eastern Washington there, the red field, and then you've got Central Arkansas there with the terrible purple and gray stripes. So all of them went through Boise to secure trademark protection, and of course Boise granted all of them and said, yeah, that's fine because none of you were trying to create confusion. And also, at least in the case of Central Arkansas and Eastern Washington, both of them are in a lower division in NCAA football. Although Eastern Michigan is Division I, like the highest level of Division I, they're obviously in a much smaller conference and much less known. So if you've ever seen, if you get bored in the fall, if you see an Eastern Michigan game, they wear gray at home, and so theirs is kind of like Boise, where they're on a gray field with gray uniforms, and man, they're hard to see. It's makes the game difficult to watch. All right, so that's it for trademark. So now on to copyright. So you can see there the conditions in order. So if you file for a copyright of something, you can see the conditions that you're going to have to meet. So you can further at the very bottom of the slide, you can see all of the things that fall under copyright protection. So things like literary works, musical works, dramatic works, so that play that you wrote, pantomimes, dances, pictures, paintings, sculptural works, movies, songs, sound recordings, architectural designs, any of those things could be covered under copyright law. So it's pretty expansive. But you can see there that the first qualification or the first criteria that you're going to have to meet is that work has to be fixed in a tangible form. So it has to be fixed in something that is physical in some way. So that can be, an audio recording of a song, that can be a video recording, so like a movie, a broadcast of a game. All of those things are copyrightable, as are things like textbooks or workbooks. Because those are very tangible, those are very physical, and you can easily touch them, right? A book is a physical thing. A music file less so, but that's still, because it's recorded, that still counts as being fixed in a tangible form. So the other qualifications on there is that the work has to be original. So, and you can see the sub-criteria there that it only has to be independently created. It doesn't necessarily have to be new. So that actually comes from a Supreme Court ruling related to how copyright works. And so the court, in part of their ruling, they were explaining their understanding or their interpretation of copyright law. And so one of the justices, and I don't have the name of which one, but doesn't matter, wrote that if you had two poets who wrote independently, who wrote the exact same poem at the same time, both of those poems would be eligible for copyright protection because both of those are original in that they're independently created. So neither of them would be new because there's in fact two of them, or I guess you could consider only one of them would be new, but because they were independently created, both of them would be considered originals. So you can't take an idea that exists and then be like, that one's mine now. You have to have done it by yourself. The second part, or the third part on there is that it has to be creative, and that's a pretty low bar. So as far as the Supreme Court is concerned, in order to be creative, all it has to do is command the interest of any public and thus have a commercial value, and then that meets the bar of creativity. So if any sort of public, whether it's sports fans, art aficionados, other architects, if any of those types of publics are interested in your work, then that meets the criteria of creativity. And then the last part there is it has to be within the subject matter of copyright. And you can see all the examples listed there. So I ran across an interesting article in a sports law journal that asked the question, could Ray Lewis obtain copyright protection for his squirrel dance? And I don't think that was the example they used, but it was the same kind of thing. So if you're familiar with Ray Lewis, he's a retired football player, played for the Baltimore Ravens, but before games, especially close to the end of his career, he had this little dance routine, basically. He called the squirrel dance that he would do before games. He was the last guy out of the tunnel. He would do this sort of semi-dance thing, and then he'd join the team, and they'd all holler, and they'd go out and run to the sideline and get ready to start the game. So, and you can YouTube it. It's pretty easy to find. And so the question is, could he obtain copyright protection for that? Well, let's see if we can meet these criteria. So the first one on there has to be fixed in tangible form. So NFL games are broadcast. So as part of a broadcast, then that's something that is in tangible form. So we can check that box off. Must be original. So he said he based it on a dance he'd seen, I think from somebody close to his hometown or somebody he knew when he was a kid in South Florida. So, but he'd put his own twist on it. So arguably it was original. Was it creative in terms of was there a public that was interested in it? For sure. Ravens fans were interested in it. And I think the dance was also used in different Ravens promos. So for sure it would meet that bar of creativity, and then must be within the subject matter of copyright. So arguably it's a choreographic work because it's a dance, and so then that could be something that would be copyright protected. So potentially athletes could copyright things like touchdown dances. I've seen the argument extended to they could copyright particular sports moves. I think that's probably a bit of a stretch, but certainly they would have the ability to copyright a dance or some sort of characteristic move that they do. The question where that might be difficult, if not impossible, is who owns control of the copyright of that tangible form. So the NFL owns the copyright for the broadcast itself, and so because of that, Ray Lewis's work could actually be considered part of his job working for the NFL or working for a club that is part of the NFL. So it would be referred to as a work made for hire, and so because of that, he might not be able to secure copyright for that dance because, again, it's part of a larger copyright broadcast to which he does not own the rights to. So it's an interesting question, though. All right, so an important thing to know about copyright laws is that they protect the expression of ideas, so their format, essentially, and not the ideas themselves. So one of the things that the Supreme Court has talked about is the idea of, or the notion of, an idea versus expression dichotomy. So there was an individual who authored a math textbook, and one of the things that he tried to do was to copyright a particular equation that he'd come up with that was in the math textbook. And so what the court said was that he could copyright the book itself, and he could control then the publication and the reprinting and the use of that book, but he couldn't copyright the idea itself. He couldn't copyright the equation because that would be against the public interest. Because if you've got this new equation that can be used for, testing the stress on beams in a bridge or something, that would be something that it would be in the best interest of the public to be able to use that widely. Now, again, he can control how often the textbook gets printed, so he can still profit from the fact that he came up with that idea, but he can't control the entirety of the idea. So he can only, in terms of the idea expression dichotomy, he can control the expression of the idea, but not the idea itself. In terms of fair use, so one of the things with copyrights is that, so I show sometimes videos that would be copyrighted. We use books that are copyrighted. I use excerpts from books that are covered under copyright protection, those sort of things. And so if you're using copyrighted material for educational purposes, in general, that's covered under fair use. But the question becomes, how much of that material are you using? So, for example, I can usually copy a chapter or two from a particular book, and I can put that on Canvas, or I can send it out as a PDF or anything like that, and that would be covered under fair use. But if I copied the entire book, well, now what I'm doing is I'm reducing the market for that textbook, and so because of that, I'm hurting the owner of that copyright there. I'm reducing their profits because I am just making copies of their book, and so that's something that wouldn't be covered under fair use. So it really takes into consideration the extent or the volume of material that you've used. So that's an important consideration. I want to make sure I didn't have anything else that I want to say about that. So another thing is generally if you're using things that are copyrighted not for profit, it's usually okay. So again, there with commentary and scholarship, that's usually covered under fair use. But if you're doing something as part of a for-profit venture, like if I am hosting, some type of an event, and I'm using copyrighted music. So let's say I'm charging at the door to get into my event. Well, the whole event is for profit, and then I'm using copyrighted music as part of it. So I may need to secure copyright permissions in order to do that. So, at the very outset, I mentioned the intro music that the Brewers use before the games, and you see that, for intro music for TV shows and stuff, they have to pay copyright fees in order to use that music. So in terms of what copyright allows you, so again, it allows you to control the expression of your ideas, it allows you to control the format. So for example, this comes up if you ever get around to writing like a professional journal article, you have to sign over the copyright of that article. So what ends up happening there is that journal, so for example, some of my recent ones in the Journal of Strength and Conditioning Research, they control that particular expression of that article. So I can't send out copies. They send you like 10 freebies or something to that effect, but I can't just make a bunch of copies of that and like post them on my website or post where people can easily read them for free. But what I can do is I can take a draft that hasn't been formatted, so it's all the same stuff, it's just in a different format. It doesn't look quite the same. So I can take effectively what I sent them that then they formatted into what they use for the journal. I can take that original version and I can post that because I still control that expression of the idea, but they control the final edited and formatted version of it. So in terms of the copyright protection, so you can see there that reproduction of the copyrighted work is protected for the life of the author plus 70 years. So and then if it's still, if the author of that work has been dead for, 50 years or, a fairly lengthy amount of time, but not quite 70 years, then sometimes it sort of becomes this gray area in terms of who controls the copyrights. So for example, there was a muscle magazine that was it's not really a muscle magazine, it was called Physical Culture, that was really popular in the early 20th century in the US. And so the publisher of that magazine, it ceased publication before he died, but the publisher of the magazine died 65 years ago, I believe. So not quite 70 years ago. So then the question is, if I wanted to use some of the images of that, how would I get permission to use those images? And so that gets kind of tough. As a personal example, I use images a lot from Muscle magazine that the editor of that magazine died in 1985. So clearly not more than 70 years since then, but the company that he started is still around. York Barbell. They're still a company that produces barbells, and so usually if you email them, they'll just give you permission. So because if you're trying to use copyrighted material, if you're trying to publish it, print it somewhere, you're going to have to show that you did your due diligence and you got the ability to use that copyrighted material, and so then that gets kind of difficult to track down. So if you own the copyright, then as you can tell, or as you can see there, you control the ability to reproduce that work, to distribute that work, and also you have control on whether or not that work gets displayed publicly. There's an interesting ongoing case related to copyright infringement, and so it relates to that picture that you can see in the lower right. So one of the interesting things about copyright is that it overlaps with an individual's ability to control their name, image, and likeness. And so what you see there is a picture of Desmond Howard. He's the guy doing the Heisman pose. So that picture was taken in 1991 after he ran back a 93-yard punt return against Ohio State, and ultimately he went on to win the Heisman that year. So the photographer in that picture is the one who actually owns the copyright, because they're the one who produced the image, and so the photographer is the possessor of the copyright, but only if they file for copyright protection. So what happened there was that in 2013, a bunch of companies started using this image and video of that event as part of a series of ad campaigns. So those companies included Sports Illustrated, Nissan, Walmart, Amazon, and then Fathead was making fatheads of those things, or of that particular image. And so a photographer whose name is Brian Mask sued all of those companies in 2013, and he argued that they were infringing on his copyright. So he argued that that particular image was one that he took a picture of, and so he owns the copyright. The interesting part about that, or interesting wrinkle to that, is that he didn't file for copyright protection until 2011, so 20 years after he took the initial picture, and it was granted. But again, he waited 20 years to file for copyright. And another interesting wrinkle here is that at that game, it's Michigan, Ohio State, it's a big time game. Even in 1991, there would have been tons of photographers out there. And so the question becomes, can Mask show that the image that's being used is the one that he took? He says that he went through and edited out the Nike checks on Howard's gloves. And so if there's a picture of Howard that doesn't have the Nike swoosh, then you know that that's the image that he took and not someone else's. The reality here, I think, is that he's probably just trying to get money where he can from these different companies. He actually sued Desmond Howard himself, and ultimately Howard settled. In 2014, the terms were undisclosed. But as far as I can tell, the last time I checked, the lawsuit is still ongoing with Sports Illustrated, Nissan, Getty Images, Walmart, Amazon, and Fathead. So I don't think if the case went to court that Mask, the photographer, would be able to prove that they infringed on his copyright. I think he's really seeking a settlement there. So, but like I said, that case is still ongoing. All right. So in terms of right to publicity, so obviously, as we've discussed previously, there is some value in being able to control your name, your image, your likeness, and then your biographical facts. And so those things are profitable. So, we talked about that in the context of Aaron Rodgers being able to control his image and then parlay that into sponsorship deals. So the most relevant case comes from the world of college sports. So if you're familiar with college video games, or the things that used to exist, so EA Sports used to make NCAA football every year. And so you can see the cover there of NCAA football 2013. And if you never played the games, they had all of your favorite teams, and they basically had the team's actual roster. So they'd have, all the players from this year's Wisconsin Badgers, and the players on the roster would have very similar features to the players on the current roster. Right, so if they had a really good, really big, strong, fast center on the Badgers this year, on the game you'd have a really big, fast, strong center who looked a lot like, in the game, the real person. Now, all they did was they didn't use the names, and then they changed up their biographical information. So they changed up their hometown and sometimes the state where they were from. But their height and weight were pretty similar, their appearance was pretty similar, the number was the same. And so effectively, they were using the likeness of an actual person, but without paying the person for using that. And so because of that, a a group of players sued both EA Sports and the NCAA. And in 2013, EA settled the suit and they paid the players $40 million, and the NCAA was found liable for another $20 million. So as a result of that, EA Sports stopped making those games, and there was a change in the way that college teams marketed their players and marketed their products. So, for example, you used to, like at Texas, one of the things that they would do is every year, whoever the most prominent players on the team were, they would sell those players' jerseys without their names on them. So, like, for example, if, your best player, so for Texas right now, the quarterback is a guy named Sam Ehlinger, and he's number 11. And so in years past, what Texas would do was sell 11 jerseys, and they would also sell whatever the year is, so there would also be some 20 jerseys, and then the numbers of probably 2 or 3 of the other best players on the team. And so the jerseys that they sold rotated depending on who the best player on the team was. So, of course, people want to buy an 11 jersey because that's the quarterback of the team right now, and so that's the number that you want to wear. So after that ruling and after that NCAA, or after that settlement, I should say, most of the college teams stopped selling jerseys other than either a number 1 jersey, or in some cases they still sell the year. So you still get like a 19 or a 20 or a 21 jersey. So what else did I want to say about this? That's most of the important stuff on that. The only other thing is that sometimes an individual can lose control of their image. And so here's an example of that. So you can see that product. It's Strongman Toilet Bowl Freshener. The guy that's pictured there is Eugen Sandow, a really famous strongman and physique star, effectively, in the early part of the 20th century in particular. So late 1800s, early 1900s is when Sandow was in his heyday. And so that's his image, and certainly he would probably not, if he had control of it, would probably not allow his image to appear on a toilet bowl freshener. But he has an interesting story in that while he was this internationally famous strongman and the most sought-after trophy in bodybuilding, so if you're familiar with the Olympia contest, the trophy for winning that is the Sandow, and so it's an image of Sandow. And so with that, sorry, I got distracted by something out the window. So with the Sandow, so he's again this really respected physical culturist, and so he had a difficult relationship with his wife, and so he also died under mysterious circumstances. Not that she murdered him or anything, but one of the stories about his death is that he died as a result of having, I believe, a stroke, because his car went off the road, and so he was trying to lift it back out of this ditch, and then he injured himself and died shortly thereafter. One of the other stories is that he died due to syphilis, and so supposedly the wife at the end of his life didn't really care for him because of the potential that he had a sexually transmitted infection. And so basically the family didn't really control his image after he died. And so Sandow's on all kinds of stuff now, especially that there's kind of been this renaissance in interest in, or rekindling of interest in strongman stuff. So Sandow is not only on toilet bowl freshener, he's also on, I've seen him on several different wine bottles. One of them is called, I think Circus Freak is one of them. They sell it at Costco. So he's on all kinds of stuff, and essentially because the family let anybody use the image, they no longer control it. And so, yeah, Sandow's on all kinds of different things, including things that obviously he would not be a fan of, like toilet bowl freshener. All right, so another question, and we only have a couple slides left, so we're almost done, is can an individual copyright a character? And so this comes up from the world of wrestling. So if you're into not Greco-Roman wrestling, but like professional wrestling, you're familiar with the idea that the wrestlers are characters. You've got good guys and you've got heels, and so they play certain roles. They have characteristic mannerisms. They have characteristic moves that they perform, outfits that they wear, and all that kind of stuff. So pro wrestling actually spends quite a bit of effort and financial resources toward character and plot development, believe it or not, if you've watched wrestling. And so one of the things that the wrestlers get compensated for is how well they adhere to the script, how well they adhere to that writing, and how well they advance the character. So WWE used to be WWF, but WWE is the biggest player in professional wrestling. So their standard contracts when a wrestler signs with them stipulate that the organization, the WWE, possesses the copyrights to the character and can control how and when the character appears. So in the contract it says that, quote, the promoter, which is WWE, shall own in perpetuity all of the rights, results, proceeds, 1 and 2, and derived from the programs, including without limitation all incidents, dialogues, characters, actions, gags, routines, ideas, titles, inventions, and other materials written and composed, submitted, added, improvised, interpolated, and invented by the wrestler in connection with their appearance in the programs, end quote. So it's a really expansive statement where WWE says they own essentially everything that the wrestler does. Not the person, but what their character does on the broadcast. WWE in the contract says that they have the copyright to all of that material. And they have that copyright in perpetuity. So the wrestler there pictured in the lower right is a guy named, his real name is Jim Hellwig, was Jim Hellwig, but the character is the Ultimate Warrior. And so he was a wrestler during my childhood. He was actually my favorite wrestler when I was a kid. He wrestled in the mid 1980s for a different competing organization called WCW, World Championship Wrestling. And when he was with WCW, he wrestled under the name Dingo Warrior. Not the catchiest, but that was his character in WCW, was the Dingo Warrior. So he got a contract with WWE at the time, the WWF, in 1987, and when he signed with the WWF, he changed his name to the Ultimate Warrior, and then his popularity soared at that point. So he became known for the face paint that you see there. He always wore that pattern of face paint, but the colors changed. And then he had the really colorful arm tassels and bottom, I don't know what you'd call the swimsuit looking thing that they wore, but we'll call it a bottom. And then he usually used bright neon colors. So again, the color scheme changed from match to match. Sometimes it would be like red and black, or sometimes it would be the really bright colors you see there. But he always had arm tassels. He always had the wristbands that you see there, and big boots, and that same basic pattern on his face. So his story was that he was from, quote, parts unknown, end quote, and he became legendary for his maniacal ring persona and almost incoherent interviews. And you can find them on YouTube. They're pretty entertaining. You can barely make out what he's saying a lot of the time. So Hellwig signed an addendum to his contract in 1989, so 2 years after he had initially signed with WWE, or WWF, and said that when he signed in 1987 that his character identity as the Ultimate Warrior had not been established. So the addendum granted rights to the Ultimate Warrior to the WWE. So that would seem to indicate that the WWE played a role in developing the character, and also that he had signed over the rights to the character. So the popularity for Ultimate Warrior peaked at WrestleMania 6 in 1990 when he defeated Hulk Hogan, who was then the reigning champion of the WWE, in front of 65,000 fans at the Sky Dome in Toronto. Ultimately, Hellwig's relationship with WWE soured, and by 1992 he was out of the organization. So since he had ended up out of professional wrestling in that organization, he went back to WCW. And when he did, he wanted to take the Ultimate Warrior character with him. And again, the WWE owned the copyright to that character. But what Hellwig did, which is a really interesting move, is he actually legally changed his name to Warrior. And so what he attempted to argue was that he was the Warrior, and so because he is the character and the name is the same, that he controls what Warrior does, which is an interesting route to go. Now, what he would have had to show was that the public couldn't separate the original guy, so Jim Hellwig, prior to changing his name, that the public couldn't separate Warrior on the street from Warrior the character. And if he was able to show that the public couldn't separate the two, that they were one and the same, then he would have been allowed to take the character with him to WCW. But of course, and again, YouTube Ultimate Warrior, it would be difficult to argue that the public would have a hard time separating the two, because obviously he wouldn't behave like that, in the grocery store and those kinds of things. So effectively what happens there is that character was created in the scope of his employment, and again, with the assistance of the WWE, so he probably wouldn't be able to take the character with him. There was a little bit more clear-cut case with these two guys that you can see there. So the individual on the left, his real name is Kevin Nash. His wrestling character was Diesel. And the guy on the right, his real name is Scott Hall, and his wrestling name or his character was Razor Ramon. Both of them did the same kind of a thing where they left the WWE and tried to go to WCW. But WWE was easily able to assert copyright control because both of those guys are very obviously not their character. Things are a little bit muddier with the Ultimate Warrior because, again, he came in as an iteration of that. He came in as the Dingo Warrior, changed to the Ultimate Warrior, and then again, when he tried to go back to the other organization, he had changed his name legally to Warrior, and so it becomes a little more difficult to separate with him than with these other two guys. So where might that matter for you? Oftentimes, if you create material which can be covered under copyright, if you do that as part of your job, oftentimes your employer will own that. And you see that too with researchers working at the university level who their research generates patents. That becomes kind of treacherous ground sometimes for those researchers because oftentimes the university may want to assert control over that patent because then the university can profit from it rather than the individual. And so then the university usually argues that the individual utilized university resources in order to create their patent, so because of that, the university owns at least part of it. So oftentimes your employer may seek to assert some level of intellectual property control over the things that you create, whether that is a character like this or whether that is something that is patentable, some sort of a new invention. Speaking of, our last slide, so patent law. So a patent is a document that's issued by the federal government that grants its owner a legally enforceable right to exclude others from claiming ownership of the invention described and claimed in that document. And so you can see a patent there pictured in the lower right. That is the first adjustable dumbbell patented in the U.S. by a guy named George Barker Winship, who was a physician from Harvard. He actually I don't think he ever actually worked as a medical doctor, but he was primarily a physical culturist, did things like put on shows and try to promote health. At any rate, that's what a patent application looks like, and this is the second one, that you can see there. So that's for a helmet. That's for a new setup to attach the helmet or the face mask to the helmet. I think that's a Riddell patent. But anyway, so that's what a patent application looks like. So things that can be patented, and so this is actually as part of the law. Things that can be patented include, quote, any new useful process, machine, manufacture, or composition of matter, or any new or useful improvement thereof, end quote. So the invention or discovery must effectively be non-obvious, new, and useful. And so patents can extend for 20 years. So remember, in terms of the time span for each of these pieces of intellectual property, your trademark, you get it for 10 years and you have to renew it every 10. In the case of copyright law, extends the life of the owner plus 70 years. In the case of patents, it only extends 20 years. So after that point, things become generic. So that's why you see, when you go to the store, if you're looking for acetaminophen is the actual drug, but Tylenol was the original brand name, and so after 20 years, they lost control of the patent, and so now you see all kinds of generic acetaminophen. Same kind of thing with ibuprofen. You see generic ibuprofens, but then you see brand names like Motrin or Advil. I don't remember who held the patent first for either of those two, but somebody owned an original patent, they controlled it for 20 years, and then after that, it becomes a generic. So you see that with drugs. That's part of the reason now, if you watch much TV or sports radio, you see like the different like Roman ads or those other ones that'll sell where you do a telemedicine thing and they'll send like ED drugs to your door. I've seen a lot of those ads lately. And the reason for that is because Viagra, one of the original drugs for erectile dysfunction, fell into being generic. The patent recently, within the last 5 years, expired. And so because of that, then there's all these generic versions of the drugs. And so that's why you see those ads. So again, you can control the patent for 20 years, and then after that, other people are eligible to use it. So let's see, what else? So in the world of sport and recreation, we might see patents for equipment like kayak hull design. Might see a patent for something like a pitching machine or fishing reel, those kinds of things. Patents can also include apparel design or game rules. So, for example, Arena Football owned a patent for their style of play. And then recent patents have also included weekly fantasy sports games, rules for various other games, including things like if you have some variant on something like floor hockey, you can own a patent for that. So in terms of patent infringement, if you're the plaintiff, you have to show that someone made, used, offered to sell, or sold, or imported into the U.S. patented material without permission. And if you're able to show that, you as the inventor can receive damages, attorney's fees, and injunctive relief, meaning that you can get them to stop producing your product or you can get them to stop selling your product. So one of the ongoing cases related to that comes from something called fair limit spray, which is what's pictured there. So if you don't know anything about soccer, like I don't, I'll tell you about what this stuff is. So the gist of this is that during soccer free kicks, a defending team has to stand 10 yards away from the ball during that free kick. In the past, the referee would step off 10 yards from the ball and then hold out his arm while the defender is bunched like a wall at that point. When the ref momentarily turned his attention away, most of the time, the defenders would shuffle or cheat up closer than 10 yards. And so by moving closer to the individual that was kicking, so moving closer to the offensive player, it makes the distance more like 7 or 8 yards, and so it's harder for the offensive player to curl the ball around that wall of defensive players. If the ref noticed that the defensive players were cheating, it would delay the game, and then they would end up ultimately getting a yellow card. So to prevent all of that delay and the cheating and all of that, there was a Brazilian inventor whose name was Heine Alamain, who invented a special foam that disappeared in less than a minute. And you can see that foam being sprayed there in the lower right. And so the way it works now is that if a player moves in front of that line, they get a yellow card. So it's much faster and more efficient than the old system of the ref stepping off 10 yards and holding out his arm and all of that. Now he steps off 10 yards, sprays the line, and everybody lines up behind it, and we're all set. So it's much quicker. So Alamain claims that he spent 15 years developing this water-based spray. He patented it in Brazil under the name Fair Limit Spray. So this first gained some notoriety or some interest in 2014 when the foam was used at the 2014 World Cup. Leading up to the event, FIFA offered to buy the patent from Alamain for $500,000, which is not nothing, but probably not as much as it was worth. And so Alamain didn't agree to sell the patent. So no deal was worked out by the start of the 2014 World Cup, but Alamain agreed to give FIFA 300 cans for use in the tournament. So they used his Fair Limit spray throughout the tournament, but his logo was covered up on the cans due to FIFA policy against commercial logos. After the tournament, FIFA changed their mind and said they were no longer interested in buying the patent, and they wouldn't declare Alamain's company as the official provider, which would have enabled the use of Fair Limit spray by leagues around the world. And so because it wasn't declared as an official provider by FIFA, a bunch of copycats invaded the market, and then so you get these other companies that produce it, and so they essentially push Alamain and his original Fair Limit spray out of the market, potentially costing him millions of dollars. So he sued FIFA, and he won an initial ruling in December of 2017 that his patent should be recognized in 44 countries, and he is seeking $100 million in damages. So, like I said, the initial ruling came from December of 2017, and I tried to, before I started this, look up and see if that had advanced at all, and I couldn't find anything since 2018. So I don't know if FIFA settled. If they did, I sure can't find anything about it. So for all I know, this appears to still be an ongoing patent infringement case. So anyway, that's the end of intellectual property. So hopefully you learned a couple things. And then next week, we'll start getting into, I think, labor law, but we'll find out. So we'll see you next week.